The Supreme Court ruled on King versus Burrell yesterday. Stick around to see what that means to you. In order to understand the case, it is best to review the history of how the Affordable Care Act became law. In 2009, Barack Obama became a president. His 2008 presidential campaign was driven by his personal agenda against health insurance companies. During the summer and fall of 2009, 4 committees in Congress met to mark up what they were told would become healthcare reform. Around the same time, Mr. Obama invited the leaders of Congress to a roundtable discussion of healthcare reform. Hindsight now shows that those meetings were nothing but political theater. In the late fall of 2009, the President of the Senate, Harry Reid, formed the Gang of Six. Along with 5 other senators, Mr. Reid met behind closed doors with these men. Their goal was to reach a workable compromise on healthcare reform. After several days, an agreement could not be reached. Mr. Reid disbanded the Gang of Six and wrote the bill that would become the Affordable Care Act himself. When Mr. Reid was writing the bill, he anticipated most objections that people would make. He provided for both rewards and penalties. However, he left one loophole that would later disrupt the entire nation. A reading of his law implies that people who live in a state that uses Healthcare.gov are not eligible for federal money. All of the talk that has come from the White House and Harry Reid himself state that the spirit of the law was to make those government payments available to all Americans. The Supreme Court was forced to decide between the letter of the law and the spirit of the law. In the case of King versus Burrell, they ruled that America must follow the intent of the law rather than what was actually written. In writing in favor of the Supreme Court's decision, Chief Justice John Roberts wrote, "The Patient Protection and Affordable Care Act adopts a series of interlocking reforms designed to expand coverage in the individual health insurance market. First, the Act bars insurers from taking a person's health into consideration when deciding whether to sell health insurance or how much to charge. Second, the Act generally requires each person to maintain insurance coverage or make a payment to the Internal Revenue Service. And third, the Act gives tax credits to certain people to make insurance more affordable." The court's decision was not unanimous. Writing for the losing side, Justice Scalia said, "This court revised major components of the statute in order to save them from unconstitutionality. Having transformed 2 major parts of the law, the court today has turned its attention to a third. The act that Congress passed makes tax credits available only on an exchange established by the state. This court, however, concludes that this limitation would prevent the rest of the act from working as well as hoped, so it rewrites the law to make tax credits available everywhere. We should start calling this law SCOTUS Care. Perhaps the Patient Protection and Affordable Care Act will attain the enduring status of the Social Security Act or the Taft-Hartley Act. Perhaps not. After all the hype and fear that this case has caused, the result is that nothing has changed. Obamacare is still the law of the land. Government subsidies are still available to households whose incomes are low enough to qualify. Americans still have to pay an extra tax. Because of the uncertainty of this ruling, during the last annual election period, I warned people to think twice about accepting a government subsidy for 2015. If the decision had gone the other way, they could have lost their health insurance in the middle of the year. I no longer feel the necessity to offer that warning.